Sometimes the courts do say they were acting under a joint enterprise or a common purpose, but that really adds nothing. They are both murderers, and I don't consider that to be at all controversial. The second situation of joint enterprise is where one person, let's say, commits murder as a principal offender, but somebody else either assists or encourages that murder. In those circumstances, the person who is the assister or the encourager may be guilty of murder as well, but only if we can prove that they did assist or encourage the murder, that they intended to do the act of assisting or encouraging. And this is where it does get rather complicated, they either intended the murder to take place, they knew the murder would take place, or they foresaw that the murder might take place. In the easy cases, conviction of the assister or the encourager is straightforward. Let me give you a couple of examples. If one person supplies a gun to the principal, intending that the principal will use that gun to commit murder, and he does use it to commit murder, then the accessory, the assister, should be convicted of a serious crime as well. That assister is clearly associated with the murder. Similarly, if somebody actually encourages the murderer to commit murder, tells them, "Why don't you kill that person?" or is present cheering on the murderer, then they are sufficiently associated with that murder as well, and so they should be convicted of murder. But what if the person who is alleged to assist or encourage is much further away from the commission of the crime? They haven't actually provided the weapon. They haven't actually said, "Go on, commit murder." Well, then it's much more difficult to justify convicting the accessory of murder. And here there's a very important point to stress that's often forgotten, particularly in the media coverage of these sorts of cases. Just because you are present at the scene of a crime, it doesn't follow that you are associated with that crime. If, for example, a fight is taking place, and I just stand by watching that fight, not saying anything, not doing anything, I am not associated with that fight in any way. So if the fight results in the death of one of the fighters, I'm not an accessory to the murder that has taken place. It will be different if I turn up knowing that there's going to be a fight and want by my presence to encourage that fight. That's different, because then I'm associated with the fight. But mere presence by itself is not sufficient. Now, there's one other point to emphasize about this form of joint enterprise liability, what we would call general accessory liability, where you assist or encourage the crime. There will be some cases where the prosecution simply cannot prove who committed the murder. If the victim was stabbed to death, it may not be possible to prove who was present and had the knife with the intention to kill. But it might exceptionally be possible to prove that one person had the knife and intended to kill, and the other people, all the other people who were present, intended to assist or encourage the murder. In those circumstances, it is appropriate to convict all of them of murder, even though we don't know who was the actual person who committed the murder, because we know that all of those present were associated in some way. But whilst that's acceptable in the easy case, this idea that everybody who is present is equally guilty does cause problems in more complex cases. And if you can't be sure that one person was sufficiently associated, then none of them should be convicted. For this principle to apply, we need to be able to establish that everybody present was guilty of the crime, either because they did have the knife and stabbed the victim, or if not, they were sufficiently associated with it. And if there is doubt about one person who's been charged as being associated with the crime, that they weren't sufficiently associated, then they should all be acquitted. Now, the third situation where the language of joint enterprise is used is slightly different. This is a situation where, for example, two people agree to commit one crime. Let's say they agree to commit a burglary. And in the course of the burglary, one of them takes out a knife, let's say, and stabs the victim, the occupant of the house, to death. That person is a principal to murder, will be convicted of murder, and that's not controversial. But English law says that the other person who didn't kill the victim may be convicted of murder, even though they didn't assist or encourage the murder, if they foresaw murder being committed as a possibility. Now that's controversial, but that means if you go along as a burglar to commit a burglary, and you think the person who you're going along with to commit this burglary might have a weapon, and you know that they have a type of personality where